Ready, start. However, it appears that though at the relevant time, there were only three regular vacancies, since the fast track courts were functioning, the appellant and others were appointed to work in the fast track courts, full stop. Subsequently, after the fast track courts ceased to function, the services of the appellant and others appeared to have been terminated. Full stop. No doubt that the termination of the appellant has been upheld by the learned single judge and the division bench of the High Court as well as by this court in the first round. Full stop. However, this court has specifically clarified that the dismissal of the special leave petition shall not prevent the appellant and others from seeking any such relief in an appropriate civil action. Full stop. The High Court has non-suited the appellant and others on the ground that an appropriate civil action would mean the proceedings only before a civil court. Full stop. The learned single judge has elaborated on as to what would amount to a single inverted comma civil action single inverted comma close by referring to the advanced law lexicon. Full stop. No doubt that the learned single judge has correctly considered the definition of a single inverted comma civil action single inverted comma close semicolon but in our view while exercising the jurisdiction under Article 226 of the Constitution of India, the court is not expected to be hyper-technical, full stop. The position that the appellant and others had, in fact, put in 8 years of service is not disputed by anyone at all, full stop. Much before the judgment of the learned single judge was delivered on 23rd May 2018, this court in the case of ABL International Limited and another versus Export Credit Guarantee Corporation of India Limited and others has held that even in case of disputed questions of fact, the High Court would be justified in entertaining a petition under Article 226 of the Constitution of India. Full stop. It has been held that even in cases where there are disputed questions of fact, where such disputes can be decided on the basis of an affidavit, evidence and no elaborate evidence is required to be led, the High Court would be justified in granting a relief under Article 226 of the Constitution of India, full stop. In any case, the state as well as the high courts are expected to be model litigants, full stop. The High Court is not expected to take a hyper-technical view, when dealing with the case of payment of salary of the employees of the district judiciary, who have actually put in 8 years of service, full stop. In that view of the matter, we find that the judgment passed by the learned single judge as well as the impugned judgment and order passed by the learned division bench are not at all sustainable in law, full stop. The appeal is, therefore, allowed, full stop. The impugned judgment and order dated 16th May 2019 passed by the division bench of the High Court and the judgment and order dated 23rd May 2018 passed by the learned single judge of the High Court are set aside, full stop. The respondents are directed to pay the salary of the appellant, full stop.